Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy, and on Thursday with attorney Chand Parvat Neni at 5:30 p.m. EST, and on Friday at 6 p.m. EST with attorney Bhanu Vinitra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to readyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, readyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The readyesq.com site provides you with the latest and cutting-edge information of US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is H1b Alternatives. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hello, Ms. Reddy. How are you doing?
Hi, good, thanks. How are you, Tony?
Very well, thank you. So before we get into the topic, there is a mass shooting that happened in Texas in an elementary school. And we're obviously devastated by this very sad news, and several of them have been killed and injured. What do you have to say about that, Ms. Reddy?
Well, it's very sad. What can I say? I have a child in middle school as well. And, for all those parents out there, my heartfelt condolences.
Right.
But I think more importantly, there's no point in this discussion unless there is some real legal reform where gun control is concerned. And to blame this on other things, to blame it on, depression, or to blame it on mental health, when the main cause is obviously guns, is simply skirting the issue to avoid, doing what your base doesn't want you to do. So, it's all politics, but it's unfortunate that politics, people think of politics to such an extent that they're willing to sacrifice lives, and lives of children. I don't really know what to say at this point. I'm just frustrated and disgusted with, the U.S. legislative process at this point.
Right. And my deepest and sincere condolences to all those families as well. Right. So moving on to the current topic that we're discussing today, that is H1b Alternatives. Would you want to start off with the topic directly, Ms. Reddy?
Yes. So alternatives to the work visa, the most important work visa that people use is the H1b work visa, and as we all know, to file a new work visa, if a person has never been on that visa before, you have to go through a lottery process, a lottery system, because there is a cap on the H1b, new H1b cases every year, 65,000 plus 20,000 for master's degree holders. So in order to, obviously, because there's a cap and because USCIS gets more cases than there are numbers available. Earlier, USCIS was doing a first come, first serve process, but that really wasn't working because all cases were submitted on the same day. So the alternative that they looked into for this was then having a lottery system. And so thousands of cases were filed. The entire H1B application was prepared and sent, and more than 2/3, majority of the cases were then sent back by USCIS because they did not make it in the lottery. So they came up with a more efficient process of the H1b registration process, whereby you don't have to to get a number in the lottery or to get counted in the lottery. You don't have to fill out the entire application, but you have to fill out a online form, which is simple enough with some basic information about the employer and the beneficiary. And based on that submission and a $10 fee, you would then be counted towards the lottery. And then if you got selected in the lottery, then you could file your H1B, and they give you 90 days to file. So it wasn't a mad rush for all the cases to go out on March 31st, so that they would reach on April 1st, the day that the lottery starts, the day that the new cases can be filed. So this is a more efficient process, and we have gone through that H1B registration process now. The lottery has been done, at least the first round. Last year we had 3 rounds of lottery because in the first round all the cases were not filed, so they had more numbers available. So we had a second and a third round as well. So we're expecting the same this year. So the lottery has the first pick of cases have been selected, and we have until June 30th to submit those cases. So it's a good time, I think, to think about, even though there are 2 more picks to come, it's a good time to think about what alternatives you have, if any, to the H1B. Is the H1B the only work visa available, or is there another work visa that through which you can bring your employers? So first we need to discuss the cap exempt. Who are
cap.
those? Yeah,
Right.
there's some employers that are not subject to the cap. So if somehow you fall into that category, maybe you may not know it, but if you do fall into that category, then you don't have to wait for the H1B cap or the next round of lottery. So the person a petitioner who qualifies for cap exempt is an employer who is an institution of higher education, or a non-profit related or affiliated to a higher education institution, or a non-profit research organization. So either an institution of higher education such as a university, or a non-profit related or affiliated to a higher education institution such as a teaching hospital, or just a non-profit research organization or a government research organization. These organizations that are cap exempt. So if you're working for one of these organizations, or maybe you want to look for a job in one of these organizations so that you can file your cap and you don't have to go back if you're already done with your F1 OPT. If you're done with all your period of F1 OPT, you might be left with no other choice but to either leave the country or to extend your F1 status or to work for a cap exempt employer. You should also remember that even being placed at a cap exempt client is sufficient to meet the cap exempt requirement. So if you're working in the IT field and your client is cap exempt, so you're working for a university as a client, though your company may be for for-profit organization, you could still count as a cap exempt. The other category that we need to look at is the O's and P's. Now, the O visa is generally reserved for individuals who have extraordinary ability in the sciences and the arts, and also in education, business, athletics. So as you can see, since it says extraordinary ability, not many individuals will qualify for these types of visas, but you could try using them in lieu of the H1 wherever possible. For example, if say you were a software developer, but you have done some extraordinary work in your field of computer science, like you've developed an app, say a healthcare app, which is useful, for COVID. I'm just giving you an example. So it's possible that you may qualify for an O and you don't have to then go through the H1B registration process and the lottery system. And the good thing is, if you qualify for an O, you might even qualify for then going forward EB1 for your green card. So that is a significant benefit if you qualify for EB1 under the same using the same criteria, because EB1 for Indian nationals is current, and no other category is in the employment based is current except for EB1. Another type of visa that you could use is the L1 intra-company transferee visa. So if your employer has a company in, say, in India and a company in the US, or is just starting a company in the US and is just incorporating it and has taken an office space, taken a bank account, and there is a clear connection between the India office and the US office. So the India office and the US office either have to be branch offices of each other, or they have to be a parent or a subsidiary, or they could be associates. So there's some types of relationships that qualify for the L1. So as long as you meet that relationship, you might successfully be able to file an L1. The additional important qualification is, of course, depending, the two types of L1s. One is the L1A and the other one is the L1B. So for the L1A, the job duties are important. So you have to qualify even based on your duties. You have to show that you have worked, say, in the India office for a period of 1 year. You have to show that you worked as a multinational executive.
Right.
So you worked as a manager or as an executive level person. You've taken executive level decisions or managerial decisions and done that kind of work. So it's important that you be able to document that, and not just by saying it on paper, not just by using statements, but also through documents. Say you signed certain, say if you're a manager, then you signed leave letters for your employees, or you signed, you did a review of their work and you signed that, or so you prepared the budget or you approved the budget. That could be an executive job duty. So you have to show supporting documentation to show that you worked in those in that field, not just
Right. Right.
few statements. So that's it's possible that you would qualify for an L1A. And L1B is that you have specialty knowledge.
You were talking about the L1B visa.
Right. So we talked about L1A. Now with reference to L1B, again, everything, all the other requirements are the same, but you have to show that the person has some specialized knowledge of the product or processes used by the company. And again, there's several ways of doing that, and multiple criteria that you can show. So if you qualify based on that, then you could possibly then file under an L1. In addition to that, there are certain countries that have specific work visas for them. And that's the, to name a few, TN, E3, H1B1. So let's go to TN first. The TN is for nationals of Canada and Mexico. And this option is available. So if, as I said, if you're a national of Canada and Mexico, and if your job falls under one of the designated occupations as per NAFTA, so there is a list of occupations, and for those who are interested in the IT field, I know I believe engineer is one job title that you could use. So IT people can apply under engineer, or I believe even systems analyst is one of the designations. So there are designations available for IT people. And the TN, the good thing about the TN is it's not subject to the cap. So you can file at any time. There is no limit on how many TNs can be filed. So that's a good thing. And so you could pretty much file, a work visa for a person anytime throughout the year. The other advantage is that for a TN, especially for Canada, you don't have to apply with USCIS. So you don't have to send in a lengthy application with the I-129 forms, etc., like you would do with the H1. You could just apply directly, not even at the consulate. You don't have to apply at the consulate. You can apply directly at the port of entry. So when you're coming into the airport and when you're submitting yourself for inspection at the airport, JFK, etc., wherever it might be, or if you're coming in by road, then it could be port of entry, at one of the land borders. In that case, you would have to submit your documentation there, and they will approve the TN visa then and there. at the port of entry itself. So it's usually a very simple process. So I would, you could always, after you come into the country, of course, you can file an extension, and if you need to do that, and if you don't want to leave the country, there is a way of doing that. Then you have to file an actual I-129 petition with USCIS. But most people, even to file an extension, will just leave the country, and come back on a new visa, or they moved to a different employer, they'll leave the country and come back with that new employer information, because it's just easier to submit all the paperwork at the port of entry rather than going through USCIS because of processing time, because of the the documentation and the forms that have to be filled out. People find it easier to do that just at the border. For Mexico, you have to actually go to the consulate. You can't go to the border, but still it's much easier than, doing the H1 and going through the USCIS, etc. So that's the TN for Mexico and TN for Canada. The requirements is same for Mexico and Canada. You have to be employed in one of the designated occupations. The other non-immigrant petition that you could file, work visa that you can file, is the Australian E3 visa. And this is also a brilliant visa for Australian nationals. There is no quota, which means you can file it at any time during the year. There's no restriction on the number of cases that can be filed. It's not subject to any cap, and the position eligibility is the same as the H1 eligibility. That is, you have to show that it's a specialty occupation. So pretty much all that's needed is a letter from the petitioner detailing the job and showing how it's a specialty occupation, what the requirements are. And the educational credentials have to be submitted along with a letter to the consulate. So the educational credentials are the degree copies, transcripts, and an evaluation. It would be a good thing to do.
Right.
US evaluator. So you submit that package to the consulate, and then they will review it, and most E3 visas are granted. So that's another great way of coming in on a work visa, but it's only specific to Australian nationals. Another one, which is the H1b one, is specific to Singapore and Chile. And that's again exactly like a H1. The only thing is that it's specific, and you can specific to those countries, and you can overcome the cap if no more numbers are available if you're a Singaporean national or a national of Chile. The other non-immigrant work visa category is the E1 and the E2, the treaty trader or the treaty investor.
Investor, yeah.
So the treaty trader visa is suitable if the foreign national has a multinational employer who's willing to transfer them, and the employer has significant trade between the foreign country and the US. And the employee must have skills which are essential to the operation of the company. And the dependents of an E1 visa holder are also eligible to work, which is great. The other one is that's the treaty trader. The other one is the treaty investor. Again, allows foreign nationals to invest, preferably a substantial amount in the US, and obtain, this is how you get the E2 visa. And this is a direct investment. So for example, you could buy a 7-Eleven, or you could buy a restaurant, a gas station, whatever it might be. So retail store. You could buy any kind of business and qualify for as long as it's a legal business, and qualify for the investor visa. The amount required for investment, it generally varies depending on the industry, and there's something called the proportionality test used. So the more capital that's invested, the more likely that you'll get the visa, of course. So if you invest 70% of the capital needed by the company to operate, more likely you have a stronger case. So you have to show it's a significant investment. So you can't invest 10% and say that you've invested and qualify for the E2. So it has to be.
Is there a particular number as to how much investment?
No, they just say significant. So I would go with over 50%.
49 wouldn't do. It's pretty much.
No, I would go with over 50.
Right. Understood.
So, and again, here dependents of E2 visa holders are eligible to work. The disadvantage of this and some of the other non-immigrant work visas that I was mentioning is that you don't get, there's no direct path to a green card. You have to again file for a labor cert. Unlike the L1, you have to file for a labor cert and then file for an I-140, 485. So it's separate from, the E1 or E2. The E1 and E2 by itself doesn't give you a green card or lead to a path towards a green card. Like an L1 does. For example, L1, if you have been on an L1 for 1 year, you can file a I-140 directly without having to file a perm. So you're getting rid of one of the steps of the green card process. And so that's the advantage. And also, it's EB1. But if it's an L1B, of course, then you have to go through the labor cert process. L1A has a lot of advantages. The next visa is the F1 visa. On an F1 visa, there are certain situations in which work is permitted. So after you finish your course, if it's at least a 1-year course, you get OPT, which is optional practical training of 1 year. This can be, it doesn't have to be paid. It can be unpaid internship. So this allows you to, or it can be paid, whatever type of job you get. So that's 1 year. And after you complete that, if you have done a degree in STEM, so in one of the STEM fields, then you get a further extension for 24 months. That's called the STEM extension. And there are, again, different criteria for that. You have to be working for at least a certain period of the 24 months and certain number of hours, and it has to be paid. So there's some criteria that has to be met for the 24 STEM OPT extension. So this is a great way for students who have just finished their education. They want to get practical experience. This is a great way of doing it. Also, while you're actually going to school, you can apply for something called CPT. This is while your program is going on. The CPT is offered by some schools, and the schools are basically, it's part of the curriculum. So the schools are treating the CPT program as part of the curriculum. So practical experience is needed for those particular subjects, and therefore for that practical experience, credit is given. So that's one way of also working while you're studying, and a lot of people make use of this option, especially when they're taking a second master's, when they don't get into the cap and they've been working already, they don't want to lose their job, they just go in for another degree and then continue their work on a CPT. There's been some controversy about when you can do that, and if you've completed a whole 2 years of STEM and 1 year of OPT, can you then go with CPT, or the other way around, because you first do CPT. If you do CPT first and you've used up 1 year, can you then again use 1 year of OPT, or have you used that up? Recently USCIS has been saying that you can't do that. But there are a lot of nuances to this, and we can talk about this F1, in a separate topic completely, a separate session. There's so much to talk about. But just important to know that there's some options on an F1 also to work. Another option is for those employers who have employees in countries where the visa numbers are available, which is other than India and China, unless you're EB1, employment-based category 1, the employer can directly file for a green card. And conceivably in about 12 to 18 months, you should be, or maybe slightly longer, maybe 2 years, you should be able to get the green card if everything goes well and come directly on a green card. So that's not a bad way of starting out your career, not having to go through the non-immigrant and then the immigrant process. But of course, it's limited to those countries which have visa number, green card availability. And so that would be ruled out, especially, for India and China, especially if it's not, EB1. If it's EB1, they can make use of that. Last but not last, Tony, last but not the least is just wait until April 1 again, the next year, April 2023, and file your H1 then, and hope that you get picked. That's, at the end, and then you have to make sure you maintain your status until then. So if you're on an F1, continue to be on an F1. If you're outside the country, then wait for another year. So you could keep doing that. There's no limit to the number of times that you can that your company can file for a registration under the H1B cap.
Now, that's a tip and a very good takeaway for all our viewers. And with that, we come to the end of the show and for H1b Alternatives as well. So, thank you, Ms. Reddy, for telling all our viewers what are the other options apart from H1B as a work visa. And it's always a privilege to host you. And there is so much information and so much that we learn from you that you let all of our viewers know. And we're very grateful for that, Ms. Reddy. Thank you so much.
Thank you, Torni. See you next week.
See you. You're watching Sakshi TV Live. This is Torani. Thank you.